Really, it's really great to see all of you who are here today. And my name is Monica Eppinger. This is the panel on property law across time and space. I am a whatever is the middle one. I always get the ranks wrong, assistant or associate professor of law. I really should be more hierarchical. I'm the middle one at St. Louis University, and I'm the co-director of our Center for International and Comparative Law. I'd like to thank the American Society of Comparative Law. I'd like to offer my thanks to Massimo Langer and all those who worked on organizing the conference, and also to Dean Takagi and the faculty of the University of Wisconsin Law School. Really appreciate everyone who's worked to make this happen, and not least Casey, our tech advisor who's with us. I'd like to introduce my co-panelists. Joining me are Dr. David Finnegan and Dr. Chrissa Papathanaceau. So Dr. Finnegan is a professor of law at Western Michigan University Cooley Law School. He teaches courses in property, international and comparative law. His research focuses on law and legal institutions in developing countries. He earned his JD and his PhD in political science from the University of Michigan. Dr. Papathanaceau, am I saying that right? Help. Can you give it to me one time so I get it right?
Papathanaceau.
Papathanaceau, thank you. Dr. Papathanaceau is an external lecturer at EBS Law School in Wiesbaden, Germany. She holds a PhD from the University of Konstanz, Germany, and an LLM from Yale Law School, and has 23 years of working experience in the public sector. Her research interests are comparative law, banking law, and fundamental rights. So with that, I think that we can go ahead and start in with our presentations. Each one of us will present for up to about 25 minutes, and then we'll have questions and answer and discussion. If anyone, I'll be keeping a queue, and so if anyone has questions, please feel free to either raise your electronic hand, and that will record you for me in the order that you've raised your hands, or else feel free to put a question in the chat, and we'll get to those after all three of the panelists have had a chance to present. So with that, if there's no further questions or discussion, let's go ahead and start. And I'm going to share my screen so that you can see some of these amazing images. The work that I'm presenting today is building on some of my long-term research projects. My PhD is in anthropology, and my fieldwork is in post-Soviet Ukraine. My most recent work has been on some of the debate around decollectivization and privatization in Ukrainian property law. Just to orient us, this slide shows where Ukraine is, which is, if I move my cursor, can you see that? Okay, so this shows where Ukraine is. It's that country between Russia and Europe. I don't think I need to tell any of you that, and also I have to tell fewer Americans after the first impeachment trial of President Trump. More people can now locate it. But that geographical position is not insignificant in this in the setting for the story that I have to tell. And what I'd be interested in today is just, I'm thinking using this presentation to bridge from past work to my next work. And so I'll be interested in your thoughts and suggestions at the end. So my geographical setting is Ukraine. My temporal setting is mostly the 20th century to the present. So from the Bolshevik Revolution to the present. I say mostly because my talk today is going to be focused on personality, and personality on collective farms or former collective farms in Ukraine implicates cows and milk. And as soon as I raise the topic of milk, at least in American legal discourse these days, I raise the specter of the settler colonial critique in regard to milk. Milk has become an emblem for those who are engaged in this critique. And for those of you, let's see, if I have, when I adjust my screen so I can see some of your faces, does that cover up my slide to you, or can you still see the full slide? You can see the full slide, okay? Okay, great. So the settler colonial critique is a critique that started with an anthropologist in Australia, but has been adopted by others in North America, those who study some of the former colonial situations in Africa. The settler colonial critique runs that that settler colonialism was a particular kind of colonialism in which the colonists' goal was to displace and replace the indigenous populations. And part of the settler colonial critique is that occupation was not or genocide was not a one-time event, but that it is reoccurring every day with the reiteration and reproduction of the structures that preserve the occupations. Which means for those who link this to milk, for example, in North America, they would say milk is not something that humans in North America had drunk before European colonization. Cows were not, domesticated cattle were not on the North American continent. Every time you drink a glass of milk, you're reenacting the occupation and hegemony and the violence against Native peoples. The Ukraine case offers us a way to think about the settler colonialism critique in a couple of ways. And to be clear, settler colonialism is not the main thrust of my paper, but if I talk about milk, I have to address it. The Ukraine case challenges this critique in two ways. To its claim about indigeneity, the Ukraine case forces us to think more specifically about the term indigenous and our study of origins. And to this, I would just say, I've written about this in recently published work, and in order to answer this point of the critique, there's evidence of human milk consumption on the territory that is now called Ukraine, back to the Tripilya culture, which is about 5000 BCE and further. And so if indigeneity is the mark of lack of violence, then we can't claim that milk in Ukraine is non-indigenous. So that's one answer. Another counterclaim in regard to milk in Ukraine is in addition to challenging the universalism that a settler colonialism critique of milk would spread, is to think more specifically about the term hegemony, and to shift our focus to ideas, practices, techniques, technologies, relations, to think about a colonization by ideas rather than strangers. And this point was raised to me by a thinker in post-Soviet Ukraine, Semyon Gluzman, who was speaking in response to Ukrainians who are questioning whether the Soviet period was a period of colonization in regard to Ukraine. And Semyon Gluzman said, if we have to decolonize, the first thing that we have to decolonize is our own minds, because we ourselves were part of the Soviet project. This was not a project by strangers. This was a project by us. So it requires thinking with a little more finesse about what's foreign and what's indigenous. There are three hidden figures in the research that I want to present today. That first hidden figure is the figure of milk, which raises that settler colonial critique. And the second hidden figure is, well, the second and third will come up in a moment when we talk about collectivization. So I want to give us three glimpses from the Ukrainian countryside into this question of personality and power. So three glimpses from the Ukrainian countryside. The first glimpse comes from the period of collectivization in which is famous for the cessation of private property rights in land, starting in around 1927 in the Soviet period, and intensifying between 1930 and 1933, such that by 1938, 98% of the land of Ukraine was in of the agricultural land was being farmed by state or collective farming and not by private farming. Collectivization in Ukraine was a particularly violent episode. Those trucks down there are confiscating grain. Theorists of Marxism would say that collectivization of private property rights and land had to happen because of aggregating the means of production under state or collective ownership as a tenet of Marxism. But historians like Lynn Viola have also pointed out through their research that collectivization in the Soviet period got its kickoff. It really got what ignited it was not the ideology, but was rather the timing of it was driven by Stalinist plans for industrialization. So if we had, Stalin wanted to use grain exports to subsidize the import of heavy industry to kickstart Soviet industrialization. In order to get grain exports, he needed the peasants to sell their grain or give their grain to the state. And people were not selling their grain primarily to the state. They were selling it on the private market. And so, as James Scott has pointed out in his work, Seeing Like a State, one of the reasons for collectivization of land in Ukraine under the Soviet period was so that the state would better be able to see the grain in order to collect it. And so what we got was massive grain confiscation. And that's what those trucks were doing in that previous slide. The status of personalty was interesting under Soviet collectivization. Personalty, farm implements, hoes, livestock, all of that was also socialized. Ownership rights were socialized, except that under Soviet collectivization law, any family that had any cattle before collectivization was permitted to keep one cow. And what you can see in this slide is a cow cattle and farm implements being confiscated from Ukrainian peasants, Ukrainian villagers. And what I want you to focus on is this image here of the woman saying goodbye to her cow, and that focus on that relationship between those two people. So I mentioned that there are three hidden figures in the narrative that I'm telling you. One hidden figure is personality. The focus of legal research into socialist and post-socialist rights often focuses on property rights, but typically on rights in land, on realty. And so the first hidden figure is personalty. And the second hidden figure is the milkmaid, who turns out to be a key figure in our story. And then the third is milk itself. Okay, so with collectivization and grain confiscation and what we got in Ukraine, at least, so we see a strike brigade here collecting grain from the collectivized peasants. We see peasants who have tried to hide their grain. These are agents of the state who have dug up grain that was hidden in a yard. What we got in Ukraine was a massive famine in which, primarily because of the grain confiscation practices, in which a minimum of 3 million Ukrainians died in the span of 3 years. It probably was closer to a year and a half, and that amounted to 10% of the population. If you consider that most of those people who died of hunger were in rural areas, and you control for urban versus rural population, the figure of those in the countryside who died is much higher than 10%. And 3 million is a minimum estimate these days. The estimates range based on the data on premature deaths, but the minimum is 3 million. So look back at that cow from the prior photograph. Any household that had a cow was allowed to keep a cow. And the memoirs from the famine that I've been able to find of people who survived the family cow was crucial to the family survival. It was sometimes calories from the cow that kept a family alive. This last photo here shows a person being treated who's starving, who's dying of hunger, who was moved to a hospital in Ukraine. And part of the response of local authorities was to try to provide milk to people who were starving. That regulation was devolved down to local authorities, so that local collective farm directors were the ones who had to come up with the milk. The norm that they were aiming for in Ukraine was that each child would have a half a glass of milk a day, and that in order to get each child's caloric consumption up to 700 calories a day. That was the aim. So it was way below that when they were trying to treat people with milk. Likewise, in the period of World War II, during the Nazi occupation of Ukraine, cattle were confiscated. Typically, the German army confiscated 50% of a village's cows, and the remaining 50% were split among the surviving households. So families might take turns milking a cow every other day. Again, milk played a role in survival, both during the period of the Nazi occupation and then when the Red Army retook Ukraine, and the remaining years of the war, there were years of great privation. I'll just speed through high socialism. So high socialism, we have a project these are the post-war years, in which the goals of the Soviet government, as enunciated, for example, by Khrushchev, were to increase consumption by the Soviet people up to US levels, specifically in meat and in milk. And this involved the application of science and industrial techniques to the countryside. And what you see here is milking machines. You see milkmaids with milking machines. And that is a very idealized portrait from 1963, I think, because what you actually had more in the countryside were no milking machines. You had these pails, but none of those tubes that would be fastened to udders. And the reason for that is because, unlike the people who were growing grain, who wanted tractors and combines, who wanted to save themselves the backbreaking labor, milkmaids, particularly Ukrainian milkmaids, resisted mechanization of milk production. And in my research, I've covered really fascinating articles by industrial designers, machine designers of the mid-1950s, who lament Ukrainian milkmaids' refusal to use their great milking machines that they've devised for the cows. And so what you see more are milkmaids without machines. And so milking remained manual labor. And the reason that I've been able to find for the resistance by milkmaids, was a system of Soviet accounting and compensation for labor. The unit of measure was something called the trudodен, the workday, and you would get paid per workday. And milking machines were a labor-saving device. You had to work more hours or work more cows in order for your work to count as one workday. A workday wasn't simply 8 hours or 24 hours. It was measured by production or by the difficulty of the labor. Because milk machines made the labor easier, it was harder to get to your through the den to work your full measure. And so people's wages were being cut because of milking machines. But also another piece of the story is the affective relations between the milkmaids and the cows. I've been able to find in my research memoirs from the milkmaids and records from collective farms in which the milkmaids think that the milking machines hurt the cows, or that they are insensitive to the cows. When the milkmaids are milking the cows, they can feel if the cow is resisting, or the cow will switch its tail or will stomp with its foot, and it will make its discontent known if you're hurting it. They worry that the cows will be harmed or will feel pain because of the milk machines. And so there's resistance on two levels. One is the very pure economic calculation of this workday calculator. But the second is the relationship of the cow. And that one of the reasons that I went into detail about the role that milk and cows played during the famine and during the war occupation was because Ukrainian cows, the lifespan was something with 15 to 20 years. So these women in the 1950s and 60s that were being told to attach these machines to their cows, they were milking either the cows or the daughters of the cows that had saved their families during the war or during the famine, or the grand cows of the famine. And so, so there's these intergenerational affective ties to cows. It may sound far-fetched, but let me take you to my research and my field work now. This is Tiocia Dusia, a woman of the host family of one of the villages where I stayed in Ukraine. And she's milking kahana. She can tell you how much milk kahana will give when she is comfortable and happy versus when she's uncomfortable or unhappy versus when she's sick. She knows kahana's favorite foods. Tiocia Dusia this time of year would spend 1 to 2 hours out in the apple orchard of the former collective farm collecting apples for kahana because that's kahana's favorite food, etc. And this is not exceptional or unique. So those affective ties of milkmaid to cow play a role in the next part of the narrative that I wanted to present to you today, and that is what happens at the post-Soviet moment. The focus in the post-Soviet moment, especially in Ukraine, which is the agricultural powerhouse of Central and Eastern Europe, it was the breadbasket of the Russian Empire. The focus was on private property rights, especially private property rights in land. And if you were to read any legal analysis of reform in Ukrainian agriculture, I would defy you to find anything that focused on personality. But in the political history of rural Ukraine, personality in the form of the cow actually played a significant role. And I will repeat to you a story from Tiocia Dusia at the time shortly after the Soviet Union dissolved. So shortly after December of 1991, within the first year or so, she and her fellow milkmaids who had been milkmaids on the collective farm, they noticed that cows were disappearing. And they noticed that their former collective farm director of their village was getting rich. And they suspected that the collective farm director was selling their cows and disappearing them. And these women know each cow by name, and they were incensed at both the inequity and the loss of this animal with which they had an emotional connection. And so the milkmaids rose up, confronted the collective farm director, and demanded that the cowshed, the collective farm cowshed, be shut down, that the herd be decollectivized, and each family be allowed to take home a cow, which they did. And this was how this village collective farm property was decollectivized, something like a decade before private property rights in land were passed by the Ukrainian legislature, before official decollectivization of collective farms in post-Soviet Ukraine. The first thing, and this was not a unique story, I heard this kind of story repeated in village after village in Ukraine. It was hard to find any village where the milkmaids had not decollectivized the herd well in advance of any de jure privatization of collective farm properties. And so what we had was an assertion of rights and claims by the milkmaids in a very gendered fashion. The collective farm directors were typically men. Those who milk the cows were almost universally women. And this had, in local effects, there were strong consequences in village politics, that the milkmaids realized that they had strength in numbers and that they had a common interest group, that they worked in unison. And so there are more results and consequences that I can tell you about milk production, that I can tell you about cheese, the cheese war with Russia. There's a lot more that I could talk about, but I'm going to circle back to the settler colonial critique, because second part of the settler colonial critique, the first one is that milk is not indigenous. The second one is that milk is harmful environmentally, that milk production has disastrous environmental consequences because of industrialized farming, the way it's been practiced primarily in North America and in Australia. And the Ukrainian case gives us an example of a modern farm economy in which milk production does not wreak the same kind of environmental consequences because the holding of cows is dispersed, the pasturing of cows is dispersed. There aren't the concentrations of waste with the environmental consequences for the water table. And so it gives us an alternative modernity to look at when we think about milk as an example of personality and power at the grassroots. That's where I'd like to wrap up my presentation. I'm going to stop my screen sharing now. And I'd like then to pass the baton to Dr. Finnegan.
All right. Thank you, Monica. The title of my presentation today is The Numerous Clauses Principle and Land Law in Africa. And so in my remarks, I want to discuss this traditional comparative law concept, the numerous clauses principle, and consider how the principle might be used to evaluate land law systems in Africa. The principle has long been used by legal scholars as a prism through which to compare the specification and content of property rights and of property law doctrine across both civil law and common law jurisdictions. Much of the comparative literature on the operation and functions of the principle focuses on legal systems in the developed world, primarily in continental Europe or in Anglo-American common law systems in the West. My project hopes to contribute to our understanding of the numerous clauses principle by exploring its usefulness in the African context. So I want to begin by describing the numerous clauses principle and then highlight some of the functions the principle arguably serves within property law systems. I then want to explore how the principle might be used to assess the state of land law in Africa using the country of Tanzania as a case study. I will briefly assess the statutory framework governing land use rights in Tanzania, highlighting a few aspects of the framework that may be characterized as inconsistent with the numerous clauses principle and its functions. I'll then conclude by discussing a few implications for further research in the area. So first, the numerous clauses principle. In most modern legal systems, there's a presumption in favor of freedom of contract, that with limited exceptions, natural and juridical persons should enjoy wide-ranging autonomy when it comes to creating legally binding relationships with others, relationships that give rise to enforceable rights and obligations. But when it comes to property rights, the presumption runs in the exact opposite direction, that the legal system should constrain individual autonomy when it comes to the creation and transfer of enforceable ownership interests or other land use rights and restrictions. These constraints are reflected in the numerous clauses principle. The principle embodies two related propositions. First, that the legal system fixes and limits the number and types of interests in land that may be created, conveyed, and enforced. Individuals and other market participants thus lack the autonomy to create and convey new and different types of land interests. The state, via its legal system, provides social actors with a fixed menu of available interests in land. You can pick and choose from the menu when deciding what type of ownership interest or use rights to create or bargain over or transfer, but you can't order off the menu. The class of available interests is closed. No new or different interests in land can be added. Numerous clauses. There's a second related proposition, and that is that the legal system defines in a fixed and ascertainable manner the rights and characteristics of each recognized type of interest. This means that individuals further lack the autonomy to bargain over and alter the characteristics of any particular interest. I think it's fair to say that there's broad consensus today that legal systems around the world generally reflect the numerous clauses principle, either by expressly incorporating the principle into the applicable code, as in some civil law jurisdictions, or through patterns of judicial enforcement of traditional and statutory rules, as in common law jurisdictions like the United States or Australia. I want to also comment briefly on some of the possible functions of the numerous clauses principle. I would say that the principle did not garner much attention among English-speaking legal scholars until the turn of the century. There were some notable exceptions, like John Henry Merriman, writing in this society's journal, the American Journal of Comparative Law, or Bernard Rudden in the UK. Several decades ago, American property law scholars rediscovered Professor Rudden's essay from 1987, published in the Oxford Essays in Jurisprudence, and this produced a flurry of work in the decade that followed. Much of this work explored the functions of the numerous clauses principle. What desirable purposes are served by building a property law system around the principle? Let me highlight a few of the hypotheses considered in the literature. One function of the principle that is identified in the literature is to protect the rights of third parties, market participants, and other social actors who are not directly involved in the creation and transfer of particular property rights. A contract primarily impacts the rights and obligations of the contracting parties, those who are now in privity of contract. But if I convey an interest in land to you, you obtain rights in the land that are not just enforceable against me, the grantor, but more importantly, against everyone else in the world, at least with respect to the asset involved. By constraining the different types of rights that are enforceable against third parties, and by clearly defining the scope of those rights, the system makes it easier for third parties to act in a way that does not contravene enforceable property rights. And this arguably reduces the risk that land use conflicts will arise in the first place, and provides arguably for a more fair and effective avenue for resolving conflicts when they do arise. So that's one hypothesized function of the doctrine. Another possible purpose served by the principle is market efficiency. Professor Rudden hypothesized that standardization of property interest reduces potential transactions costs associated with conveyancing, particularly measurement and information costs. And by reducing those costs, this enhances the alienability of interests in land and contributes to a more robust and efficient market for real estate titles. Professors Merrill and Smith examined this hypothesis in some detail in their work on optimal standardization in the law of property. Finally, specifying property rights in a manner consistent with numerous clauses has been argued to provide a stable playing field on which property rights can be contested over time in a manner consistent with the rule of law. Standardization provides a focal point around which social debates about property can be framed and understood and hopefully resolved. And this hypothesis was developed, for example, by Professor Davidson in his work on standardization and pluralism in the law of property. So how might we think about the numerus clausus principle and its potential functions in the context of African land law systems? I want to briefly consider this question by examining the case of Tanzania. Several decades ago, the government of Tanzania substantially revised the legal regime governing land use rights in both urban and rural parts of the country. In 1999, the parliament enacted a pair of new statutes that together now govern land rights for Tanzanian citizens. One statute, the Land Act, governs the creation and disposition of interests in land, primarily in urban areas like cities and towns. The other statute, the Village Land Act, governs the creation and disposition of interests primarily in rural areas. Although the statutory framework created by these acts on one level appears consistent with the numerus clausus principle, there are features of the framework that, as applied, may cut against achieving the purposes of the principle, and I want to provide a few examples. So the Land Act in Tanzania identifies the categories of interests in land that may be created, transferred, and enforced in the country, including rights of occupancy, leases, mortgages, easements and covenants, and rights of co-occupancy. And in a manner consistent with the numerus clausus principle, expressly declares that only interests in land recognized under the statute will be enforceable. Let me quote the language of section 61(1) of the Land Act in that regard. That section provides, quote, "No right of occupancy, lease, or mortgage shall be capable of being disposed of or dealt with, except in accordance with this act. And any attempt to dispose of any right of occupancy, lease, or mortgage otherwise than in accordance with the act shall be ineffectual to create, extinguish, transfer, vary, or affect any right or interest in land," unquote. You can't vary a right or interest in land other than in a manner permitted under the statute. In that regard, the act closes the categories of enforceable interests in land, numerus clausus. At the same time, the statutory framework creates rules and procedures that, as applied, may undercut the numerus clausus, that may impede the ability of the legal system to accomplish the purposes underlying the principle. Let me provide two examples. One has to do with the role played by government administrators in the creation and transfer of interests in land. The other has to do with legal pluralism, and in particular, the specification and enforcement of customary land use rights in the country. First, the Land Act authorizes substantial administrative variation in the scope of possessory rights in land, both at the time the rights are granted and then later when those rights are subsequently transferred to others. The primary form of possessory right recognized under the statute, the main form of title available in Tanzania, is called a granted right of occupancy. The government grants these rights to applicants and issues certificates of occupancy to them, at least initially. Once granted, the rights can be disposed of in a number of ways by the occupier, including by sale. The granted right of occupancy lasts for a finite period of time as determined by the government, up to but not exceeding a term of 99 years. So in Tanzania, when you apply for a formal title to land, it takes the form of this granted right of occupancy, which generally lasts for a 99-year term and which is subject to renewal under certain circumstances. Certain preconditions must be satisfied in order to obtain a granted right of occupancy. The land must have been surveyed, any certificate that is issued must be registered, the applicant must pay a fee to the government called a premium, and the holder of the certificate must pay an annual rent, also fixed by the government. And the government has the right under the statute every 3 years to revisit the amount of rent and to revise it periodically. And the statute provides for consequences for failing to pay the annual rent to the government. This rent operates more or less like a property tax of sorts. Finally, and significantly, the right of occupancy is subject to use conditions imposed by the government at the time the certificate is granted. And a failure to abide by those conditions may lead to fines or even a revocation of the right. You might lose your right of occupancy. Certain conditions are prescribed in the statute or established by applicable regulation. For example, if the right is obtained for purposes of building on undeveloped land, well, then the occupier must apply for a building permit within 6 months of obtaining the right of occupancy. You can't let the land lie unimproved for very long. If the land is to be used for agricultural or pastoral purposes, then within a certain period of time, a certain percentage of the land's area must be cultivated or stocked with cattle. But the government also has broad discretion by statute to impose, quote, any additional condition which it considers necessary or desirable to ensure the beneficial occupation and use of the land that is subject to the right of occupancy. So, although citizens do not have the ability to alter the scope of land use rights beyond the menu provided by the Act, the government does have discretionary authority to tailor the scope of each particular right of occupancy granted. And this arguably expands the menu of enforceable interests in land beyond a discrete and limited number of categories. Administrative discretion impacts the disposition of land rights in another significant manner. The Land Act requires any person proposing to carry out a disposition of land to first notify the government. And certain types of dispositions are then made subject to prior government approval to be valid. The implementing regulations, for example, include a sale of a right of occupancy as a type of disposition requiring prior government approval under the Act. Now, the Land Act establishes a presumption that applications for a grant of approval for a disposition shall be granted. But then it lists factors that the government will consider in deciding whether to abide by the presumption and approve the disposition or instead to reject the application. For example, one factor is whether the proposed sale price is too low. Another factor has to do with the amount of land already occupied by the applicant. The implication is that if the buyer already has too much land, well, this may be sufficient to rebut the presumption and the sale will not be approved. So the right of alienation, the power to transfer enforceable rights to others, is made contingent on government approval, at least for some types of dispositions. These examples of administrative discretion, authorized by statute and applicable to most granted rights of occupancy, inject an uncertainty into the scope of land use rights. This uncertainty introduces transactions costs into the market for land titles in Tanzania in a way that arguably cuts against the underlying functions and purposes of the numerous clauses principle. Let me comment on one other example. This has to do with the treatment of customary land use rights. Like other African jurisdictions, land law in Tanzania exhibits a high degree of pluralism. Different bodies of substantive customary law govern land use in different parts of the country. The formal legal system recognizes and enforces these customary rights. It is fair to say that in Tanzania, the Land Act and the Village Land Act codify customary rights in land by making them enforceable within the formal legal system. For example, under the Land Act, rights of occupancy include not only those expressly granted by the government, but also customary rights of occupancy. And the statute establishes procedures for validating and formalizing interests in land held under customary tenure. It expressly provides that quote, dispositions of customary rights of occupancy shall be governed by customary law. Now, by its terms, the Land Act applies primarily in urban and peri-urban areas. That is, it's intended to govern land rights in and around cities and towns. By contrast, the Village Land Act, the other main land law statute, governs land rights primarily in rural Tanzania. The Tanzania Natural Resource Forum estimates that village land covers 70% of the country, and so is governed by the Village Land Act. About 3/4 of the population of the country lives on village land, and 80% of that group are small-scale farmers. By contrast, only 2% of the country's land mass is governed by the Land Act. The Village Land Act provides that any village land may be held under a customary right of occupancy, and the scope of the right will be determined in accordance with customary law. In most cases, the applicable law will either be the customary law that applies in the particular village or that is recognized by the persons occupying the particular land. The statute establishes procedures for persons or groups to apply to village government to obtain a formally recognized certificate of a customary right of occupancy. The government issues a certificate, which is then entered into a register that's maintained by the village government. Keep in mind that the Village Land Act does not codify substantive rules of customary law or recognize any one particular body of customary rules. Instead, it codifies recognition and enforcement of customary law as a legitimate source of rules governing land use rights, bringing customary land use rights into the formal legal system. The substantive content of a particular body of customary law may still be contested. The existence of particular customary rules must be shown to exist. The scope of customary property rights must be proven. And this, to some degree, injects uncertainty or contingency into claimed rights in rural areas. In any event, the greater the degree of legal pluralism within any system of land law, the larger the menu of available interests in land, the less likely the system will reflect the numerous clauses principle. There are trade-offs to be made between the desirable public policy justifications for protecting and enforcing customary land use rights on the one hand, and on the other, reforming the system to better achieve the purposes underlying the numerous clauses. Well, let me conclude in this way. These brief observations about the state of land law in Tanzania suggest a few avenues for further research on the numerous clauses principle. Numerous clauses is traditionally concerned about the law on the books. Its focus is on doctrine, whether property law doctrine confers upon individuals legal autonomy to bargain over, create, or transfer new types of property rights. If the formal legal rules constrain this autonomy, the system conforms to the numerous clauses. But other aspects of the legal system may very well shape the manner in which interests in land are specified, created, and transferred in practice. So, for example, in the case of Tanzania, patterns of discretionary administrative decision-making, or the degree of pluralism reflected in the system of land law. And so going beyond the law and the books, this suggests several related empirical questions that are worth examining, perhaps by employing the type of social science research methodologies referred to earlier today during the opening plenary session. One is to test whether, to the extent the law in the books reflects the numerous clauses principle, whether the principle holds up in practice as an empirical matter, as a matter of the law in action. Are there other aspects of legal doctrine in a particular jurisdiction or patterns of institutional enforcement of the doctrine that frustrates the numerous clauses and impedes the realization of its purposes? The other is to test hypotheses about the functions of numerous clauses. For example, reducing transactions costs in the market for real estate titles. well, maybe we should test that hypothesis by collecting and evaluating empirical data to assess the degree to which those functions are achieved in practice. This type of research would allow us to better evaluate the effectiveness of land law regimes and suggest potential avenues for reform and improvement. Those are my comments, so thank you.
Thank you so much, Dr. Finnegan. And now we'd like to turn to Dr. Papathanaceau.
Thank you very much.
Thank you all so much. Now we have time for questions, answers, and discussion. And if you have a question, please raise your electronic hand or raise your physical hand, although I may not see you all, or feel free to place a question in the chat function. And I'm happy to wait for that, but in the interest of time, I'd like to start with a couple of questions of my own. And one question is just, I have a question for you, Dr. Papathanaceau, about where you would take or where would you like to take this line of inquiry next? Would you want to select other court speeches? Do you think that there are different disciplines other than the ones that you've drawn on that you could use to analyze this speech? So I'd be interested in the depth or breadth that you'd be taking this project. And so that's kind of about the future. And for you, Dr. Finnegan, my question would be about the past. Is there a sense of what preceded numerous clauses in Tanzania? That's right. So I'll leave that for both of you. Any other questions we're happy to entertain.
So would you like me to share a few thoughts?
Sure. Why, if you could, and then we have one question that's popped up. So let's go ahead and get some responses to that first question, and then we can start hearing questions from others.
Right. So just thinking about your question, the new or the relatively recent land law reforms in Tanzania were prompted by a significant shift in economic policy in the country beginning in the mid-1980s. Up to the mid-1980s, so from going back 20 years from that, the country pursued an economic policy that could be characterized as Agrarian Socialism, where when it came to agricultural production, output in the rural areas was collectivized. There was a program for, at first voluntarily, but then later forcibly resettling rural villagers into collectivist villages for communal agricultural production. And during that era, which was called using, or was termed ujamaa, using the Swahili word, the law in the books was largely ignored. And the executive branch accomplished these tasks by fiat. But beginning in the mid-1980s, the government sort of abandoned that socialist economic policy and began to liberalize the economy. And by the late 1990s, there was sort of a view that some of the laws and legal institutions were kind of outdated, that they needed to kind of be revised to better accommodate a more market-oriented economy. And so in part, the new land acts were intended to accomplish that purpose. The other thing I would say is that the framework that created by these acts largely replicates, in my view, the structure of the colonial era laws, the pre-independence approach to land use, in that following World War I, and the start of the British mandate, the colonial government focused on property issues primarily in urban areas that were the concern of the colonizers, and left kind of the rural areas to be governed primarily by the pre-existing customary framework. So there was this bifurcated urban versus rural kind of legal system put in place during the colonial era. And so it's interesting to me that under the current statutory framework, that continues. There's this bifurcated system where there's one statute that's meant to apply in urban areas and another statute that's primarily meant to apply, creating rules for rural areas. So yeah, there's history certainly embedded or reflected in that statutory framework.
Thanks.
Shall I give it a try? Yeah, what's next? It's a good question. Actually, I would love to study more speeches and try to, using the methods of comparative law, try to unlock more mysteries and see what type of contracts they used in the 4th century BC. And the reason is that it's quite interesting time. It is a time of crisis for the Athenian economy. We have also evidence that the mining was difficult or was they had to excavate deeper and deeper to find ore that was very expensive. So there was a time of crisis at some point. And for those who are interested in how humans react to crisis, I think it's a very interesting time to study and to see what type of legal institutions were in place, how they were employed, how the courts behaved towards the contracts. And the second thing is we have a lot of mining areas in Greece around that time, but also throughout the Eastern Mediterranean area. And it would be interesting, but I hope that that could be a second article, to see, was it that thanks to leasing that the mining districts were so many in Greece and in Eastern Mediterranean, in the Eastern Mediterranean area, or was perhaps another factor that we don't know? That would be interesting, but it's a little bit of a detective. You have to be a little bit like a Secret Service agent. You have to try to reconstruct what might have happened, because the resources are there, but you need to put the pieces together. But I think that would be an interesting question, like how many mines did we have around that area, and did they prosper because of leasing or because of some other factor?
So law and economics on both counts. I see a question in the chat that was sent to me. What type of rights did the milkmaids have over the cows? Was there any difference in their attitude depending on the type of rights? And this came to me from Dr. Papathanaceau. So did you have in mind during Soviet times or post-Soviet times?
Post-Soviet times, because I guess during Soviet times, they didn't have probably any rights, but I don't know.
Right. So during Soviet times, there were any household that had a cow or any cattle before collectivization could keep one. And the others were taken by the state and given to the collective farm or the state farm. Sometimes that household then was absorbed into the same collective or state farm. And so you have you might have a milkmaid who used to milk 3 cows, and after collectivization they've kept one, but then they've become part of the collective farm, and she gets to see her other 2 cows every day when she goes to milk those. So the usufruct rights to the milk were, if your household had a cow, you had superior rights to that milk, but the collective farm milk or the state farm milk belonged to the collective or the state. And so the milkmaids got paid either a salary on the state farms or typically a share of profits on the collective farms of the group's production, but not of maybe a proportion to, according to a calculation of their own effort. But they didn't get to keep the milk. So the milk only belonged to you if it was your household's cow, which really proved to be a life and death matter during the famine and during the war. I see hands from Simeon Simeonidis.
Yes, yeah, thank you. Well, I guess you can tell from the name that I'm Greek, which also explains why I'm so fascinated by Dr. Papathanaceau's presentation. And there must be an easy answer to my question, but I didn't catch all the terms in the contract or in the excerpt that you showed at the beginning, and maybe that's the answer. That's where the answer is. My question is, why did you rule out so quickly the possibility that this might be a usufruct? And then I said, well, the easy answer is because the silver and the copper you take is not a fruit, it's product. But if the object of the usufruct is a mine, I think that products of the mine can be analogized to fruits. And if that is correct, this could well be a usufruct unless there are other terms in the contract that preclude that. And while answering, could you please address this other question of ignorance, maybe? I assume that a usufruct is an older concept than leasing in the Greek world or in the Greek-Roman world. And if that is true, then perhaps it helps the possibility that this was a usufruct. So thank you. But everything is so interesting. All three presentations I really enjoyed. Thank you.
I think it's not ruled out. It's just that it's very possible that the borrower enjoyed usufruct. The thing is that you cannot then explain the entire structure. Why does the party pay the money to the owner, becomes the owner of the workshop, then leases it to the borrower, then he pays rent, and he pays the concession fees? And I think usufruct is correct in a way for the right of the borrower, but it alone, it does not give a name to the entire transaction, which is part of one economic transaction. There are so many parties, there are so many different rights. I think we have many rights here. I'm just giving a name to this entire contract. But there's nothing against, I think you're perfectly right. There's nothing against saying that Papathanaceau, the businessman, has usufruct over the factory. It's plausible. I don't find anything in the speech in favor or against, but okay, it's open for interpretation. I was just trying to figure out, with every kind of other property or contractual right, I always had a piece missing. This was my, okay, he has usufruct, and all the rest, why does he pay rent? Why does he do that? Why didn't he get the money to buy the workshop? Why do the new owners pay the money to the previous owners? Why is this so complex? And while I was trying to figure out why all these elements, I could only come up with this contract. And of course, the historians told me, how does this help me as a historian to know that today's name of this contract might be, because we're not so sure, might be leasing? And I would say to them, because naming is framing. And if you frame this contract as complex and obscure, and you don't get further. But if you name it as leasing, you can start understanding who's the owner, who's has usufruct, as you rightly say. Why did they have that? And then you start entering this fascinating world. Like, they need this silver to mint coins. And why do they need the coins? And I will come to something that Monica said when she started the introduction. I almost fainted because I was like, oh, the grains again. Because they needed the coins to buy the grains from the Black Sea region in Crimea, Ukraine. Yeah, that's where the grains of Athens was not enough for the population of Athens. So they needed to import grains from the Black Sea region. And they desperately needed the silver to mint the coins. So it's only then that you realize what they're doing. You understand the whole context. It's functional, it's economic, it's historic, it's micro comparative, fine. It's not the entire legal system. We don't know enough about the entire legal system, but what you say is absolutely plausible. Yes, I think he does enjoy probably usufruct, yeah. And probably this is why they had a written contract, because they had, and that brings me also to what Dave said before, that you have these numerous clauses. Why do you have these numerous clauses? Because you want to protect the third party's rights. So they put everything in writing because they wanted to protect not only their rights, but also the third party's rights. So they know who's the owner, who has usufruct, who's the lessor, who's the lessee, who pays the concession fees to Athens, and so on. This is not something that you could do orally, obviously. And this is probably why it is written. But I don't want to be anachronistic. I don't want to, in today's world, we would say you cannot have a property right based on an oral contract. You always have a written deed somewhere. I don't know if that's true also for that time, but certainly the fact that we have a written contract seems to suggest that this is something special here.
Thank you for that. I want to point out to my fellow panelists that there was a question in the chat. If you go to the bottom of your Zoom screen and you select the little bubble that says chat, then you can make the chats appear on the side. There's a question about whether the papers are available online. On my topic, there's a precursor project was published recently. And as we heard Massimo Langer say this morning, the University of Wisconsin International Law Journal has invited us to submit these presentations for publication in their online symposium. And so if you have something that's been published on these areas, then I think that some of our attendees would be interested in knowing the citation. And if not, it's something to think about. The online law journal, I took a peek this morning. It looks like they are looking for essays of 500 to 1,000 words. So it would be a short distillation. It would not be the full encapsulation. I'd like now to hear a question or comment from Professor Binyami.
Thanks very much for those fascinating presentations. And I think we were able to actually name the panel correctly, because it truly is across time and space. So my question really is for Professor Finnegan, and I have a smaller question for Professor Eppinger. But the question for Professor Finnegan is on customary law, because when you teach the subject comparative law, you get the jury globe map, where I don't know if you've ever seen that, but it's colored, right? And you have common law, civil law, Islamic law, customary law. And so my students, when I give them this map of the world, they always ask me, so what's customary law? And so this is a very nice illustration. And what I am working through is trying to understand what it is that the Tanzania Land Act, both the urban one and the village one, was replacing. So it seems like it incorporates this body of law, which has to be proven, and then it replaces customary courts and puts it into another legal system. I suppose that's my question. Is it replacing a pre-existing form of dispute settlement, Or is it building on and just allocating, sort of codifying what was there before? So that's the question for Professor Finnegan. And then the question on the Ukraine, you know, the milk thing is really interesting to me. I know nothing about the Ukraine really, but it is so present in contemporary debates. And you allude to that in the setup to the presentation. But it seems like your presentation is really a pro-milk presentation, if I could put it that way. Like, it's hard to kind of understand how it is that milk could be, you know, have a pro and a con, but it seems like yours is actually, you know, is somehow pointing to the value of milk in a culture and a tradition and a series of property relations. But I don't know if I'm misunderstanding, and so I'd like to maybe hear you on, you know, where you stand in the milk debate.
Go ahead first, Dave.
Sure. Yeah, in my view, these statutes, and there's actually a more recent statute called the Land Disputes Courts Act, which addresses your question a little bit more directly. But in my view, these statutes build upon pre-existing dispute settlement mechanisms, and then just sort of charge these different institutions with responsibility for implementing the act. So, for example, at the village level, the primary government institution is the village council. And historically, the village councils were made up of elders selected by the community. And those elders were given responsibility for allocating land to village members for productive use. Under the statute, the village council accepts applications from villagers to have claimed customary land use rights recognized. And then the village council decides on whether the claimed right has merit and will issue a certificate. If there's a dispute, that dispute is heard primarily by that body, the village council. Decisions of the village council, though, then can be taken to ward tribunals and then to district land and housing tribunals and appealed from there further to the High Court. And this Land Dispute Courts Act directs these various layers of judicial review to base their decisions involving disputes over claimed customary rights on applicable customary law that then has to be proven by the litigants in that connection. So not only do these land acts adopt substantive rules that relate to claimed customary rights, but then there's also statutes that govern how those rights are to be, how disputes over those rights are to be resolved in the courts, applying available and applicable customary law.
Super. And I want to direct attention to the chat, a contribution from one of our participants, Professor Donovan, on the question of what the statutory law is replacing. There's a fascinating book titled Legal Pluralism in Ethiopia that addresses exactly that question, how the statutory law interacts with the pre-existing customary law systems. And I am so grateful for that because, and I apologize, during your answer, Dave, I was turning behind me to look at my own bookshelf because there's work by an anthropologist who I believe it was in Tanzania. Her work is on gender law and markets. And so when you talk about village elders, I just wanted to call forth or question, does that mean men? Because the hidden figure in my story is the Milkmaids. And if you see a narrative of collectivization or post-Soviet reform, women are far and few between, but it turns out at the village level, there were gendered spheres of activity and there were some areas in which women were really the dispositive force. But I'm curious if that, I need to respond to Professor Bignami's question, but just wanted to pose that too, because a lot of times when we don't say the gender, it means men, and when we do say the gender, it means women. The question about, I got so involved in listening to your question and Dave's answer that I forgot what your question was to me. Can you repeat it? Muted. Sorry, we're muted.
Where you stand in the normative debate on milk.
Oh, thanks. Right. Okay. Yeah. So I started with the normative claims about milk, and I have to admit, I was a complete babe in the woods when I started working on milk, and it wasn't until going to a workshop or two, well, my first workshop with people who do work on milk law. And luckily my presentation was first. So I went in completely naively and just said what my research had led me to think without bracing for impact. But it turns out that there is a big milk debate, and the anti-milk side is has very strong convictions, and they have very good reasons. I am afraid that my fieldwork in Ukraine has biased me. The milk is delicious. And the last time that I went to my field site, a local person that I was arriving at the village with, you go by train out of Kiev to the north, and then you get off at a train station and you walk for about an hour through some woods, and then you get to this village. And we were arriving at the village, and we saw some women at the edge of the village who just looked very healthy and kind of vibrant. And it was summertime and everyone was kind of glowing with good health. And my companion said to me in Ukrainian, the women here have milk for blood. And not coincidentally, a friend here in St. Louis asked me, because we take a walk a couple times a week, and so she was getting the updates on my milk research, and she finally asked me after a couple of months, do you ever find yourself craving milk? And I realized that my milk consumption had kind of tripled over the course of working on this research. And I just had a doctor's appointment where the bad LDL cholesterol level is super high right now. So one part of the critique of the anti-milk people is that it's unhealthy. And if humans were meant to drink non-human milk, that it wouldn't be unhealthy for us. And I think that the answer that the villagers that I've worked with in Ukraine would answer is, if it were that unhealthy, we'd be dead. It's only for milk that most of us have survived the 20th century. So that's sort of I said there were 3 hidden figures. So one of the hidden figures is milk in the story of survival. And so that predisposes me to be pro-milk, but it's an admitted, it comes with an asterisk. It's an admitted cautionary tale. Lactose, I'm an anthropologist, so I can't forget the physical part of being human, and lactose intolerance seems to be the default state for humans, and it took genetic mutations to develop lactose tolerance. May I say in my indigeneity defense that archaeological finds have found the gene for lactose tolerance in the human remains in the territory of Ukraine about like 3,000 years earlier than the closest neighbors in Central and Western Europe. So I'm still arguing for indigeneity, but not all the way back to our African origins. So that's part of my asterisk is the indigeneity claims need to be more finessed and can't be universally applied, which I think that's also, I come out where Professor Papathanaceau comes out, in that I am a fan of comparative law and I see its values. I also think that some of the other claims, I love Ukraine for providing this alternate vision of modernity, this kind of radical alterity. It just, if you go from 1917, if you look at things like agricultural production in the United States and in Ukraine, there are things about crop breeding about milk production that look very similar. And then in 1917, things go like this. And they go like this in a way that did not turn back the clock. The Soviet project was really a science, industry, and progress narrative. It just is very different. So it gives us an alternate path of comparison. And part of that alternate path is seeing now milk production that is dispersed and is not necessarily environmentally harmful. That in a time when inputs into grain and vegetable production have dropped because of post-Soviet unraveling of economic networks, dispersed pasturage of cows has provided fertilization of fields that otherwise might have been depleted. So it doesn't, the environmental story also is not a one-way story, but it might soon become, because the land code, the last step in implementing the land code passed within the last 1 year, creating a secondary market in agricultural land in Ukraine. And so the assumption is that big corporations are going to gobble up all the little holdings. And so this picture of dispersed agricultural production, including in milk, is not long for this world. We'll see if that prediction comes true or not. I had, if no one else wants to jump in, and also I'm just biased because I really love milk products, and Ukrainian has, if you go into an open market in Ukraine, they have milk products that I've never seen before, and I don't know the words for in English. You know, there's if you put the jar of milk out and the cream rises to the top, and then you put that jar into the wood-fired stove after you've banked the coals for the night, it produces this yummy, delicious product that is not sour cream or cream cheese or butter. They have an amazing amount of milk products that are just delicious. And so I don't see how I could be honestly anti-milk, although I need to watch it. But I will take it with an asterisk that the environmental consequences could soon be severe, that there are individual human health consequences of which I should become better acquainted and more aware. So far, in the post-Soviet economic unraveling, in village households that have had to resort to autarky, or maybe got to resort to autarky in a lot of areas of their lives, milk was one of the few ways of accessing cash. There are daily milk collections with refrigerator trucks, and so villagers can sell their milk for cash. It's one way that they get their hands on cash. So anything that they don't produce themselves that they need to buy or to pay taxes or school fees, milk has kept people afloat. So even now, it's the story of rural household survival, and the lifeline from milk is not just a thing of the past, it's a thing of the present. And so I can't be too anti-milk, but again, those affective relations and those survival, the functionalism of survival that may be unraveling as the land code changes relations further. I had one question or suggestion for Dr. Finnegan, and that was to add to your list of future research. And the list would be who gets to decide what custom is. So if some of the research could look at village disputes in which custom is invoked. And I'm really borrowing this question from work by Justin Richland, who's an anthropologist of law, and I believe he's at University of Chicago, and I don't know if he's primarily in anthropology or law, but could be in either one. His work is on Hopi traditional courts, and the name of his first book, I believe, is called Arguing with Tradition. And it's a double entendre. It means when tradition is invoked to argue in court, but also it's disputing, coming to blows with tradition. And so my question would be, who gets to decide what custom is? And does that get worked out village by village? What are the doctrines or the power networks or dynamics involved in that? Because that seems to be maybe one of the hidden figures in your story.
Yeah, no, thank you for that. And I think there are a number of empirical questions that some of these thoughts beg and are worth investigating. Well, one thing I would note, and this responds to both your this comment and your earlier comment about gender, is that the statutes attempt to address gender issues in them. For example, in the Village Land Act, in the section that talks about the applicable customary law, the act provides that under no circumstance will a decision over a claimed customary land use right be enforceable, and this is the quote, to the extent to which it denies women, children, or persons with disability lawful access to ownership, occupation, or use of any such land. Now, okay, that goes as far as the law in the books. I think the better question is, in practice, what is the dynamic, at issue? And that's an empirical question. I agree.
Well, I think it was fascinating to hear post-socialism implicated in your work, and to hear the grain trade hidden in the background of your work. I think it's about time for us to wrap up. So unless there are further questions, I'd like to thank again the American Society of Comparative Law, the organizers of the conference, and my fellow panelists. I found both of your work rich and interesting. So thank you for the participants as well. Stay in touch, everyone. Be well.
Thank you.